Good afternoon, everybody. My name is Brian Tully. Thank you for joining us for our Wednesday webinar. We're going to be talking about protecting your pot of gold. Of course, related to March. We've done this one a couple times before, but a little different today. So we'll get started in just a moment. I want to give some time for people to be able to log on, and then we'll get moving. All right, everybody, we are back. Thank you for joining us today for our Wednesday webinar. Again, my name is Brian Tully. I am the founder and managing partner of Tully Law Group. We've been helping folks with their elder care needs and estate planning needs for 27 years throughout Long Island, New York City as well. And what we're going to be talking about today, relevant, of course, to good old March and St. Patty's Day, is we're talking about how to protect your pot of gold, shielding your assets so that you can pay for and get the best long-term care later on, when and if and when it's ever needed. So we're going to get going. First, before I start, just like always, let's just make sure that you are seeing my screen. I am sharing my screen right now, and that you can see me and hear me. So if you could please just give me a thumbs up in the chat or the Q&A, that would be great. Let's see. Just want to make sure, again, you can hear me and see my screen. If somebody can give me a thumbs up or a yes, then we can get moving. Great. Thank you very much. Okay, so questions. If you have questions, I'll be happy to answer them at the end. Go into the Q&A or the chat, whichever is available on your toolbar there. Enter your questions and I'll answer them. Also, we don't cover everything in this one webinar. We've been doing webinars for, it's literally 5 years at this point. And so our website, tullylawgroup.com, has a webinar page, and you could see all of our past webinars if you wanted to get to learn a little bit more or dig a little deeper in some of the topics we're going to cover today. Or you could always just reach out to us directly. I'll have all that contact information at the end. All right, so here we go. So when we talk about protect, what exactly are we talking about? What kind of risks are out there as we're aging? What can jeopardize our financial accounts? And first and foremost, and what we're going to talk about today, is the idea of long-term care. We get into it, we deal with it every single day. That's what my law firm has been built to help people with. So we'll touch upon that. Also, however, there's a risk of guardianship. That's when somebody hasn't done the planning in advance and they lose mental capacity. That's a risk out there. That gets addressed briefly today, but that's not the focus of what we're talking about. In addition, there's a risk of probate, which is like guardianship, is it throws your family into the court system. And whenever you're in the court system, it's going to take a lot of time, it's going to be very costly, and it's going to be very stressful. So there are ways to avoid probate and avoid that risk. Again, not the thrust of today. And ultimately, there are risks out there once you're no longer here and the inheritance is hitting the next generation. So there are issues that can happen if a house, if an investment account, if a life insurance policy is landing in the lap of your children, and perhaps there's a divorce going on. Perhaps they're in the middle of litigation. Perhaps they're minors or disabled. So there are risks out there when it comes to aging and planning and protection. Again, today's focus, though, is going to be on long-term care. We've covered the other topics in our other webinars on our website. Or again, you could reach out or ask me questions afterwards. So how exactly do we protect? So what we'll get into today is we'll be talking a bit about irrevocable trusts as opposed to a revocable trust. And surprisingly, maybe for some of you, is we use powers of attorney to protect. And we'll get into what is a good power of attorney and what is a bad power of attorney. And why do we have that as an avenue to protect? Because if you yourself cannot protect your assets, then your duly appointed power of attorney agent can do it for you. So we need both of these in place, among other things, but this is how protection can happen and cover all of our bases. All right. So 100%, we are talking about assets today. But if you know me, if you know us, if you know our logo, right, we've got our shield, but we also have our heart. We're doing this because of our clients. It's about mom and dad, it's about husband and wife, it's about grandparents. Ultimately, if we spend all of our money, we're not going to be able to have the quality of life or the dignity that we do wish to have for our loved ones. So we address the assets not because all that matters, that's all that matters, but because that is what makes up our family. That's what how we can help our family. So keep that in mind, okay? So we'll start with this. What exactly is long-term care? So today's topic is protecting your assets so you can get the care that you need. And for those of you watching today that have been a part of our previous seminars and webinars, you know I always kind of lay a foundation because there are new folks out there. So the concept of long-term care is one where you have to realize there's a difference between medical care and long-term care. Medical care is the type of care people need from at any age. It has nothing to do with age, but it's medical care that requires doctor intervention or nurses, hospitals, rehab centers. It's diagnoses, it's medical conditions, okay? And those medical issues and conditions are generally covered by our health insurance. So that's not what we're talking about today. What we're talking about is long-term care, which is when somebody needs assistance with what's called the activities of daily living or the instrumental activities of daily living, okay? So an activity of daily living, we'll explain it momentarily, but it's when somebody needs assistance with their physical abilities. There, you see the walker there. So walking, bathing, toileting, etc. And instrumental activities of daily living, the IADLs, as you could tell by the image, that is more about cognitive, and that's about processing. And as we're aging, we look at these things. And our perspective is always to help the family realize it's not just about the money, it's about the care, and it's about how we are aging. So we utilize this elder care continuum that's on your screen now so that people can visualize what may happen. And perhaps you've seen this with your loved ones in the past, whether parents or grandparents. So on the top line there's visually depicted a gentleman as he's progressing. And there, all the way on the left, there's no cognitive, no processing, no dementia, no short-term memory loss, no cognitive decline, and no functional decline. So they're good on the left. But then as we visualize it with the gentleman with the cane and then the walker, what you start looking at is there can be some limited function, either physical or cognitive. And then that can increase and increase and increase, or the physical abilities can decrease and decrease. The cognitive abilities can decrease until we get to the right side of the continuum. Now, the line below that represents the house, when we're good and independent and handling our bill paying and our medications and our transportation, then we're independent and good. We're in that house alone. But the next step is you might need some assistance. And whether that's one person, whether that's a child stopping by in the morning, perhaps it's a child stopping by at night, or a neighbor. It starts out informally. And then, as you can tell in the depiction, it starts to become more formal gradually. So ultimately, people end up hiring aides to come in to assist with those activities of daily living, such as getting out of bed, or walking, bathing, toileting, dressing, grooming, and eating. Those are the 7 activities of daily living, and it's what you do every morning without thinking about it. Or perhaps there's assistance that's needed with medication reminders, or transportation or paying bills, all those, again, instrumental activities. But what we see here is there's a progression. Yes, somebody can go from left to right in a moment, if God forbid there's a massive stroke. Or it could be gradual, right? If we're talking about the different horizons and what can happen with different disease processes, we have our coronary concerns, we have our pulmonary concerns, we have our cognitive concerns. They all have different timelines. But this is a good way to picture and realize that this is what may the future may hold for our loved one and even for ourselves. So if we need this type of care, what does it look like and what does it actually cost? So what are we protecting from, right? So home care is where an aide comes into the home. And if you can do that informally, like I said, with family, you can hire the person down the block, you can hire somebody from church. It's doable that way. We don't recommend it because they may not be trained. They may not be background checked. They may not have insurance. So for our projection of costs and why we want to protect, we're using agency expenses. So if you actually engage a home care agency, you're looking these days at about $32 to $40 an hour for an agent, for an aide from an agency. What that typically translates into for 24/7 care, where the aide actually has a place to sleep, is you're looking about $400 a day to a little over $500 per day. Break that out monthly. Home care can be $12,000 to $15,000 a month. I've got clients a little bit more than that right now. Why? Because they're paying for around the clock care. They're paying for an aide to be with dad at 3 in the morning, 4 in the morning, 5 in the morning, as opposed to letting the aide sleep. So the actual depiction and need for care will determine what kind of care you need and the kind of expense that you're going to have. We've seen home care at 4,000. We've seen home care at 18,000. It all depends on what the needs and the wants are. Annually, though, home care, you're generally over $150,000 a year. So you look at that and you go, well, mom and dad, they have a house, or we have a house or a condo, and maybe there's $200,000-300,000 in savings. Maybe there's not. Maybe there's more. But you have to take this into account. Home care can cost this. The next step up the level of care, as far as the level, is assisted living. These facilities, we see them almost on every corner at this point. A lot of them are really good and they serve a great purpose. The idea of socialization, the idea of community, very, very valuable, and why these communities do thrive. But you have different components to the expense. You can have the room and board, which is generally $7,000 to $10,000 a month. You can find a couple that are a little bit less, and you can find a couple that are a little bit more. And you just break that out monthly, or forgive me, annually. But the other level is you got to add the care. So if you're not living in your home and you're living in an assisted living, room and board is covered with the rent fee, that charge. But if you still need an aide, you have to pay for that on top of that. Okay. The next level of care, and again, why we need to protect, is a skilled nursing facility, a nursing home, as we call it. And unfortunately, these prices and costs have gone up as well. You're around $500 to $600 a day, which is about $14,000 to $20,000 per month. Times that out over the year, you're $150,000 to over $200,000 a year to pay for a nursing home, out of pocket. And that becomes real cost prohibitive for many, many families, definitely for middle class. All right. So that's why we're talking about this. So how can we shelter what we need to shelter and get some help to pay for the rest of the care? So long-term care in and of itself, there's three ways to pay for it. There's out of pocket, just what we were talking about right there, using your own money, using your income, perhaps using IRAs and 401ks, but do the math. $100,000 a year for 5 years, that's $500,000 for home care. $200,000 a year, you're going to go through $1 million if you're paying privately. And maybe that works. Some families, they have to do that. Other families, they do not. Some people, actually assign or push the risk onto an insurance company. And there's what's called long-term care insurance. You can purchase that, generally younger, healthier. It's like life insurance, right? You have to be insurable to obtain it, and you have to be able to pay for it. So long-term care insurance can also pay for this care, these costs we're talking about. But ultimately, a lot of folks must rely on what's called Medicaid. Okay. Medicaid is a government program, the federal involvement, state involvement, county involvement. It is a complex bear of a process. There's eligibility issues, there's application concerns, there's assessment issues. I can count on one hand, and I've been doing this for 27 years, I can count on one hand how many families I've sat with and I've said, you don't need us to do this work for you. And you don't need us to help you apply for Medicaid. And that's because there are no assets whatsoever. The person is already eligible. We don't have a spouse to worry about. We don't have a house to worry about. The care is already established and needed. So the advocacy for the hours of care is diminished less than 5 times. So what I'm getting at is Medicaid is complex. Medicaid is a bear, and you're not going to know you made a mistake with the process and the eligibility until you get the approval or disapproval 4 or 5 months later. Okay, so don't play with Medicaid on your own. Again, if there's a spouse, if there's assets, if there's income to protect, and so forth, or care issues, and that's of course where we come in here at Tully Law Group. But Medicaid in general is about 3 things, and this is one of those points where I am not getting into depth as far as Medicaid eligibility. You can go to our website, tullylawgroup.com, go through our past webinars, or catch one of our live upcoming ones and learn all about Medicaid eligibility. We do it all the time. But big picture, Medicaid eligibility is about 3 things. It's about a person's assets, it's about a person's income, and it's about how much care that person needs. So when we're talking about care, we're talking about protecting their health, their dignity, and we have a way of doing that. It's a very unique way of doing it called life care planning. We are the only law firm in New York that is a life care planning law firm. So we have a care team on staff to help your loved one get the best care possible. That's not what we're talking about today. There are ways to shelter income in a home care situation. Sometimes in a nursing home situation if you have a spouse, but generally income protection is a home care scenario, which can be done for some or all of the income. What we're primarily talking about today is that top one there, the assets. How do we protect our assets? How do we shelter our home? How do I shelter that investment account? A good thing to know is you don't protect retirement accounts, okay? So what we talk about today is you're not utilizing or transferring your IRA to anybody or anywhere. You keep those IRAs and 401ks and 403bs and qualified annuities. You're keeping those assets because they're retirement assets. You keep those accounts and assets in your name. That's part of the trickery, if you will, of all this eligibility talk. So we're talking about non-qualified, non-retirement money and real estate, of course. So what are our options to protect? Well, we have trusts and we have powers of attorney. Generally, irrevocable trusts are what are used when we're talking about long-term care. An irrevocable trust is one that's going to have the protections built into it to shelter assets. In essence, conceptually, we build a wall around the assets. We divide the assets from the owner, from the potential Medicaid applicant, or the seniors that want to plan and protect in advance. So the use of an irrevocable trust, we'll talk about that. And again, powers of attorney, we'll get into that a little bit more now. So a trust itself. And I don't mind admitting this, but I've been practicing since 1998, graduated law school in 97. Thank God, passed the bar the first time, got sworn in January of 98. I was intimidated, and by the way, always estate planning and elder law. That's what I've always done. So when I first got out of law school, started doing it, wills and plans and so forth. But I'll admit, as a young attorney, I was intimidated by trusts. I felt that they were irreversible in some ways and that I didn't want to make a mistake. So I was hesitant about utilizing different types of trusts because I didn't know enough about them. As I started to learn about trusts, the different types of trusts, the provisions, the purposes, the benefits, through my own learning and working with a mentor and so forth, these became secondhand. It's what we do every day. We utilize trusts because they are fantastic. There's many different flavors, if you will, of trusts, and they're used for different purposes. But in essence, to take away all the intimidation, a trust is nothing more than a written agreement. That is all it is. It's a written agreement between different parties, which I'll explain briefly. But this written agreement really talks about three different parts of your life. It talks about what's going to happen with your assets while you are alive and healthy. And then the second part is it's going to talk about how to use your assets and manage your assets when you're alive but not healthy. And then it talks about what happens to your assets once you're gone. Okay, so it's a written agreement covering those three parts, segments, if you will. But every trust has to have different people involved, like I mentioned a moment ago. You have to have a grantor. That's the creator of the trust, the person granting it. Some attorneys use the phrase trustor or settlor. I don't like those. They don't make sense to me. Grantor does because they're granting it, they're creating it. And then you have a trustee. The trustee is the manager. So here simply the person setting it up and the person managing it. Now, where it gets a little confusing is in some trusts, like revocable trusts, that's the same person. I am the grantor of my own revocable trust, and so is my wife. I am the trustee of my own revocable trust, and so is my wife, of her trust. But irrevocable trusts are different. Irrevocable, IRREV, those are the ones set up for asset protection purposes. So we would typically have a child as a trustee, if possible. If not, a sibling, a close friend, and so forth. So there's different ways to do it. But you have to have your creator and you have to have your manager. And ultimately, you have to have a beneficiary. That means who benefits from this trust agreement. You could be a beneficiary of income. You could be a beneficiary of principal, of what's inside. You could be a lifetime beneficiary. So while the grantor is alive, you benefit. Or you could be a death beneficiary, which means you benefit after the grantor passes on. The last requirement of a trust is you got to put something in it. If you typically it's a house or a financial account, but if you've ever seen a trust, the last page has what's called a Schedule A. It's simply an informal, meaning it's not binding, it's an informal listing of assets owned by the trust. And if you're not putting a house in there right away at that time, you simply write $10 because you have to show that there's something, some money, some asset within the trust. Okay. Now, there's two types of trusts. I've been mentioning them so far. There's revocable and then there's irrevocable. Different purposes. So let's talk about that. The revocable trust and the irrevocable. Those are the two types. There are two purposes primarily that people do trusts. They do trusts first to avoid probate, which is that court proceeding I mentioned briefly in the beginning when a person passes away. And they also do trusts to protect assets. Okay, so two types of trusts and two purposes. These trusts are different. The purposes are different. Now, a revocable trust is primarily built to avoid probate. That's what it does. It means that your house is owned by your revocable trust. You pass away, that revocable trust will detail who inherits the house after you're gone. You don't need to go to court to get a judge to tell you where it goes, okay? It happens almost automatically. Now, because an irrevocable trust is still a trust and can own a house, it will also do the same thing. So both trusts avoid probate, okay? However, as far as the other purpose of using a trust, only the irrevocable trust is one that will protect your assets. That's the one that we utilize when we're talking about asset protection for long-term care. It could also be used for other purposes, creditor protection, estate tax protection, and so forth. But in order to gain protection, it needs to be irrevocable. And again, this is another topic I'm not getting too much into today. We have plenty of webinars on our website, on YouTube, talking about that. The important point to realize here is that the revocable trust does not offer asset protection. So if you have a revocable trust, and we sit with clients like this, not weekly, I'd say monthly, where they come in at 75, 80 years of age with a revocable trust, that doesn't work for long-term care asset protection. Doesn't work for any asset protection for that matter. So if that's the goal, that's what we're after, we then have to do an irrevocable trust. Okay? So the word irrevocable, we're going to talk about this for a few minutes. I'm going to go a little quick. Understand, again, there's more in-depth talk about this on the website, tullylawgroup.com. Our YouTube channel, Tully Law Group, has plenty of videos on it as well. We just released some a couple months ago. Now, to get into this irrevocable trust, some things you need to know about it. First and foremost is it will trigger a look-back period. So in the context of Medicaid, there is only one look-back as of now. Again, another topic we talk about in other videos. It's a 5-year look back for nursing home care and nursing home Medicaid only. In essence, that means you want to protect your assets 5 years before you go into a nursing home. The problem with that, which has already hit you, is that you don't know if and when you're ever going to need a nursing home. So that's why we want people to plan and protect as young as possible. 60s, 65, get the protection going so you can start this 5-year window, go live your life, and then it ends. You know, do it in 2025, go live your life. Next thing you know, that 5-year window is over in 2030, okay? Now, I have a 30 number there as well. There is no look back for community home care Medicaid as of now. That can change. There is a law on the books signed into effect in 2020 that says that there will be a 30-month or 2.5-year look back for community home care Medicaid services. It just hasn't started yet. It can start at any point. We have a webinar coming up next month with the director of Suffolk County Home Care Medicaid. We've been doing this for a couple of years now. So keep an eye on your email and you'll get an invite for that one to learn more about this topic. Now, next point. Anything inside of a trust, that is called the principal. In a revocable, REV, the money is yours, you can use it. In an irrevocable trust, because the purpose is asset protection, access to the principal is limited. The principal, the house, the money in the trust can never be distributed back to the grantor who set up the trust. It can't be used for their benefit. One of the biggest, thickest rules, if you will, that has to be understood about an irrevocable trust. There are other ways to utilize the money inside and to distribute it, but just understand this rule has to be adhered to. It has to be in the trust and it has to be adhered to. That's how you get the protection. The trust can be built so that income from the principal can be distributed out if it's necessary. A trust will always say, if it's done correctly, that the grantor, whether it's mom and dad, they have the right to live in the house for the rest of their lives. So we put our home into an irrevocable trust, they can rest assured knowing that they've got the legal right to live there. The trustee can't kick them out, okay? That's important to know. In addition, real estate taxes and other expenses all remain the responsibility of the grantors, of the parents. So you're still paying taxes, you're still paying the expenses. Good news though is they remain the same. You don't lose your exemptions, okay? If it's an irrevocable trust, you've got the ability to sell, you've got the ability to buy with the assistance of the trustee. Speaking of trustee, the next point is you're in charge of the trustee. So if you pick your eldest child, which I don't always recommend, as your trustee, you can fire them. So if you have Stephen, your eldest child, as your trustee, and he doesn't want you to sell, fire him. Then the next child will step up, or the next successor that you name in the trust will step up. So you have the ability to remove trustees and appoint different ones if you'd like. Same thing with beneficiaries. So if you pick your 3 children as beneficiaries and want to change it, you can. So you can still decide who inherits, even though it's an irrevocable trust. You can remove Stephen if the relationship has unfortunately declined and there is no relationship. You can disinherit a child. You can add grandchildren. You can add charities. You're in control as to who inherits, just as if there was no trust. In addition, we recommend that a trust protector be appointed within your trust agreement. It's somebody outside of the family. Generally, there's no compensation for it whatsoever. They're just serving in this role in case flexibility is needed. So, for example, we do a trust protector in each of our trusts. And that's where, if the law changes, the trust protector can amend the trust. It's an irrevocable trust. The grantor parents can't amend the trust. They can change trustees and change beneficiaries. That's different. But if they need to amend a substantive term, they can't. But a trust protector can. Just another level of flexibility. Another point about these types of trusts is the taxes remain the same. I started to mention it earlier. So real estate taxes, don't lose your exemptions. Income taxes remain the same. You're paying the income tax on income inside the trust, just as if there was no trust. And capital gains taxes, a more weighty conversation. But the good news is the capital gains tax exemptions and what's called a stepped up basis for the beneficiaries, that all remains in an irrevocable Medicaid asset protection trust. Okay. Last point, and I sometimes don't want to say this one because I don't want people to do this. An irrevocable trust is revocable. If everybody involved, if parents, children, all beneficiaries agree, trustee agrees, you can get rid of it. Okay, so that makes some people comfortable knowing this is not an undoable mistake, if you will, because it's rarely a mistake. It's usually the best thing you're going to do. So we want people to know they can change it and revoke it if they have to. You need everybody involved to do it, but we don't want you to. And again, just like I said earlier, I can count on one hand how many people have actually revoked their trust. Okay. It's not something that happens. Where it does happen, to tie it up to the first point we mentioned, is if we do a trust and in hindsight, it's too late. So if we do an irrevocable asset protection trust in 2025 to protect the home and other assets perhaps, and sometimes, by the way, we do 2 trusts, but we can't stay out of a nursing home for 5 years. What if there's such a decline or something real tragic occurs and we need a nursing home in 2027? That's where we can have this trust revoked in a crisis. Okay. So a lot of flexibility. You look at the idea of irrevocable, but then you look at the reality. You still get to live there. You can sell, you can buy, your taxes are the same. It's the right move for most people. However, I want to address, well, why not just give the money to my kids, right? So people will say that, why can't I just put my kids on the deed or give them all the money? I call it the D's, and it's a nice green D for St. Patrick's. Your children can have your money and they can die, or they can become ill or sick or disabled, disease, if you will. They can divorce with your money, and perhaps that's half gone. They can have addictions or drug concerns, alcoholism, and misspend your money. They can have financial problems and debt. They can be flat out dishonest. We know there are children and we love them, but that doesn't mean that they're going to do the right thing all the time. There can be increased taxes or a duty, if you will. I had to get the D in there. And my favorite, they can just do something dumb. I've seen it. So if you just give the house to your child, you're going to have a tax problem, you're going to have a security problem, you're going to have a real estate tax problem, a capital gains tax problem. They could just invite people to live there. They can sell it without you knowing. If you give them $50,000 to hold, which is sometimes done on purpose, but if it's not the right person to hold the money, maybe they're going to Atlantic City, right? You got to be careful of the plan. And it needs to be, it's one of the reasons that internet forms and internet planning and working with people that don't do this every day is faulty, because you might think some of these ideas are good, but when you're sitting with a counselor at law that's been doing this for 5, 10, 15, 25 years, you're going to hear back as to what's the benefit, what's the pro, what's the con. And you don't get that from a computer. Okay. So that's the irrevocable trust. Let's spend a few more minutes on how we can also utilize and protect with a power of attorney. The big picture is a person can set up an irrevocable trust to protect their assets on their own. But if they don't have mental capacity, if there's a diagnosis of dementia or something else has occurred, then their power of attorney agent can do it for them. All right. But it has to be the right power of attorney. It is the most important basic, or what we call foundational, estate planning document there is. There's also a will, a healthcare proxy, a living will, but the power of attorney, most important. It's where you're picking somebody to help with legal and financial decisions. You do not want to use an internet form. You do not want to use a simple form from a title company or from a bar association. You need an attorney to be crafted to what your potential needs are. It's what we call a durable modified power of attorney. New York State hasn't made this easy. They've changed the law 3 times in the past 16 years. The last change was in 2021. So durable, you'll see the word up there. Durable means that the document will remain valid even if you were to lose mental capacity. So that's crucial when we're talking about planning and aging. I also use the word modified. The power of attorney has a special place for modifications to be inserted. They need to be inserted. That's how you take a general power of attorney form and build it into an elder care or an aging or an estate planning power of attorney. Asset protection issues get added into the modifications. Income protection, the ability to do that. Retirement accounts, business interests, those powers don't exist in a standard form. They need to be added by the attorney, okay? It has to be executed properly, witnessing in certain places, notary, signatures, initials. Trust your agent and your successors, of course. If it's done correctly, you can avoid that guardianship I mentioned earlier. That's that court proceeding when there's no power of attorney or the power of attorney is done incorrectly, okay? Now, we're talking about protection, irrevocable trusts, durable modified powers of attorney. When do you do them? Do you do them in advance? Do you take the time to plan for your family? Some have said estate planning is the ultimate act of love because you are setting up a plan to make their lives easier, less stressful. So, do you set up a plan like this in advance or do you deal with it in a crisis? I say this all the time. A crisis, which is what most people unfortunately end up in, is always going to cost you more money, is always going to leave you with less options, and is always going to be more stressful and take longer for that matter. A crisis is not what you want. Think of the LIE and a flat tire. Happened to my son 2 months ago. It was a miserable experience. Of course, it started to snow. It was 8 o'clock at night. It was dark, and there was already snow on the ground. So he had this much room to park. It was miserable, but it was a crisis. Now, planning in advance means that you're taking care of this. You will save time. You will save money. You will have more options, and it won't be a crisis. There'll be less stress. Okay. So when should you protect your assets? Yes, the answer is now when you see our pot of gold, getting back to St. Patrick's, of course. The way we do this here at Tully Law Group, and again, it's a unique process. It's what we call our Elder Care Protection Plan. Every plan that we do is not a transaction. When we're working with families, and how we've been doing it for so long and so successfully, thank God, is that we build relationships with our clients. We are here for our families and their children when they have questions. We're here if they have changes. Every plan we do has what we call a client care program attached to it. So we're here for the year. We're here to help, and we can be with you for year 2, year 3, year 4. We can talk to advisors, we could talk to CPAs, we could talk to children. And the Elder Care Protection Plan is the irrevocable trust plan that we utilize very frequently. It's what's required, in our opinion, when we're looking at aging and the potential of paying for long-term care in the future. An Elder Care Protection Plan is going to include a comprehensive last will and testament. the durable modified power of attorney that you need to have in place before something happens. And we don't know when something's going to happen. A healthcare proxy for healthcare decisions, a living will for end of life treatments, the irrevocable trust we've been talking about, and access to our ECCs. That's another very unique provision of how we operate. An ECC is an elder care coordinator. We are the only law firm in New York State with a care team of elder care coordinators, registered nurse, geriatric social worker, case manager. When we're dealing with a long-term care issue, one of those actually become the advocate, right? That's a different service and a different webinar that you can find on our website. But even in an elder care protection plan for a healthy 65-year-old, if you're going into a rehab center for your knee, we'll help you decide, if you'd like, we're here and available, which rehab center to use and which to stay away from. If you need respite care, if you have other concerns or questions, you can talk to them. They're not fully available at this level of service for advocacy and crisis intervention. Again, that's another level of service when we actually have a care need. That's what's called a life care plan. So our elder care coordinators are there to assess the situations continually. They will coordinate the care, they'll coordinate the providers, they'll coordinate the benefits, they'll advocate for you. And when we're getting into this community Medicaid situation, there are 4 or 5 different assessments at the end of the application process. One of them is sitting next to you, advocating for you or your parent, grandparent, to get into the program and get the hours of care that's needed. They'll support the family caregivers and they'll intervene if there's a crisis. Ultimately, whenever our elder care coordinators are involved, and this is what we're known for, is there's going to be a peace of mind knowing that the bases are covered, all right? And when we get involved with a family, we're looking at the whole person. We're not just a transaction focusing on the legal aspect of aging. We're not just a transaction focusing on Medicaid, because we also focus on the care needs. And these are what we call the domains of aging. Every senior, in person for that matter, but every senior in our context has legal concerns, has financial concerns, and has care concerns. So our goals when we're working with a family is, on the legal front, is to help them protect as much of the assets as possible. On the financial front, we have to get that care paid for, and for most people it's Medicaid, and we'll do that. We have a fantastic Medicaid department and planning department. These are real children, real people. Their parents, their siblings, their children, just like you are. And we'll do the work that's needed to help you protect the assets, get the Medicaid to pay for the care, and help your loved one get the best care possible. That traditional elder law firm that I'm talking about will only handle the legal and financial needs. They leave the care off to the side. The care advocacy, the intervention when there's a crisis, the coordination of the benefits and the providers, which home care agency, how many hours am I going to get? That's all on the family with a traditional elder law firm. The way we do it, again, is different. We bring it all together under one roof with what we call life care planning. So when we're talking about asset protection for younger and healthier for the future, that's the elder care protection plan. Can't go wrong with that. That's that irrevocable trust we spent so much time on, and the power of attorney. But when we're actually talking about the care need, when we have the legal, the financial, and the care needs, that's the life care plan that we help with. And we've been doing that life care service for 16 years at this point. Hundreds of families that we've worked with to help them navigate the whole long-term care maze, if you will. So there are things to protect. You want to do it in advance so that you can get the care you need and get it paid for later on. All right. I am out of time. So are there any questions? I'll be happy to answer any questions. We had a good bunch of people on today, which is great, and everybody stayed through. Always great to see that. My direct email is Brian, Brian, at tullylawgroup.com, tullylawgroup.com. That's our website as well. You can call the office, 631-424-2800. We offer free consultations just to hear what's going on and talk about how we can help. Let me see if there's any questions. Okay, so question which is a typical one we've been getting, so I'd be happy to answer it, Donnie. The question is, I saw an IRS ruling that seemed to nullify the shielding of irrevocable trusts and the assets inside about a year and a half ago, um, and expressly block Medicaid eligibility and so forth. That is not the type of trust we're talking about. We saw that when it came out, of course. We've read it through, and so have all of our colleagues, and then the Bar Association and so forth. That that type of irrevocable trust was not a properly done Medicaid asset protection trust. That dealt with typically the step up in basis. That it was a tax provision within the trust, and what do the actual children inherit tax wise when the parents pass on. And we include and have forever what's called this power of appointment. That does away with the concern and the point of that article in the revenue ruling. Okay, Donnie? So our trusts are fully allowable and acceptable for asset protection and for inheritance benefits tax wise. So they're still good. So please explain the stepped up assets. Sure. So the best way to look at that is I'll talk about my own parents. So my parents bought their house. I grew up in Malvern. They're still there, thank God. They bought the house in 1971. I was 1 year of age, for about $30,000. In Malvern, the house could be worth $600,000-700,000 at this point, $800,000. So what you look at there is the purchase price is the initial tax basis for the asset. Same thing with stock. If you buy Coca-Cola stock at $1, that's your basis. And then you look at, well, what's the value when the person passes away and it's being inherited by the next generation? So again, my folks, I've got two brothers. So me and my two brothers are going to, again, years from now, Lord willing, inherit the house. And we inherit under current federal and state law, we inherit the property, and again, could be stock as well, at date of death fair market value. So if the house is worth $800,000 when they're gone, because it's years from now, then we get the property with that tax basis. It's a stepped up basis. Sometimes there's a stepped down basis, but in this case, real estate on Long Island, it's a stepped up basis. So we inherit the property at $800,000. That's the tax basis. We can sell without paying capital gains taxes. That's what a stepped up basis gives you, and why it's so important with real estate, especially on Long Island. Next question. How is the elder care protection affected if somebody moves out of state? Great question, Gail. As it is for always, if you're moving out of state and you know you're doing it, and it all depends on the timing of when you're doing it as to whether you still do the New York planning or not. But let's say you have it in place in New York and you decide to move. A lot of states recognize the irrevocable trust in other states. So for example, Florida and North Carolina, they all accept this irrevocable trust. But you want to talk to an attorney in that state. So you let us know you're doing it. We'll recommend somebody that knows what they're doing. You sit down with them. You might have to tweak the trust a little bit. You might have to update the power of attorney. You'd have to listen to that attorney down there. Powers of attorney are very state specific. So it'll work while you're here, and it should work where you go, but you want to just verify that with an attorney down there or wherever you're going. Okay. My children have rocky marriages. How do I prevent the in-laws, the spouses, from getting the assets? That has to do with inheritance planning, which again is another webinar. But the big picture there is when you're looking at an inheritance, it can be outright, meaning they just get a check from the estate or the trust when you're gone, and now it's their money, and it becomes marital property perhaps, and now it gets split 50-50 at divorce. So leaving assets outright can be subject to divorce. The alternative is leaving an asset to your loved ones in further trust. So you're saying, I have my own irrevocable trust for my house, and when I pass on, I want my children to receive the house in trust. So they don't have direct access to it. There will be a trustee, perhaps a sibling, that can govern distributions and how to invest the property inside. But just like the trust protects you from Medicaid, the trust for them can protect them from divorce. So it's a discussion to have, again, with your attorney, okay? Hopefully that was helpful. You're very welcome. All right, everybody. Thank you for Joining us today, we will be doing more of these, of course. We do them monthly. Tully Law Group, we're here for your elder care and your estate planning. And reach out and let us know how we can help. See you next time.